السلام عليكم أستاذ. Hi.
وعليكم السلام ورحمة الله وبركاته.
We are ready to start, inshallah.
إن شاء الله العزيز. Okay. Right, people, let's begin. بسم الله الرحمن الرحيم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما وعملا وإخلاصا وتوفيقا يا أرحم الراحمين. Were there any questions that I had to take before we begin? Or was that in the Aqaid class?
I had a question, Ustaz,
Yeah.
but
Yeah.
it's on my notes. I haven't opened up my notes yet, so maybe I
No
can
problem.
cover.
It's just that I just signed in and I kind of remembered. That's all. That's
Yeah,
fine. When you remember, it's no problem, right?
I
So,
can ask them at the end of the class, maybe.
maybe. It's just that because then we kind of sometimes run out of time. Your questions are left, and I'll probably tell you then next week. That's all right. Sorry, I'm just got a bit of a headache. Let me see if I can wear this hat on if it helps. Right, come on then. So I have here bookmarked ولا حد على من وطئ جارية ولده وولد ولده وإن قال علمت أنها علي حرام. And وإذا وطئ جارية أبيه أو أمه أو زوجته أو وطئ العبد جارية مولاه وقال علمت أنها علي حرام علي حرام حد وإن قال ظننت أنها حلال لم يحد. Um, I gave you a bit of an introduction before we started approaching these cases last lesson. If you recall, these cases are tied in with suspending the had, dropping the had, based on the hadith ادرأوا الحدود بالشبهات or الحدود تندرئ بالشبهات, and there's other such wordings that the had punishments are dropped due to doubt. And I mentioned to you that doubt is of two types. There is doubt that is created by scripture, what we call shubhatun fil mahal, or what's known as shubhatun nas. Right? If you guys remember, there was shubhatun nas or shubha fil mahal, which is that the scripture itself creates possible ambiguity or creates doubt. And then there's something called shubhatun fil fi'l, that the person committing the crime himself misunderstood or was under an incorrect impression, was under the wrong impression. And the rule I mentioned to you is that where shubha fil mahal, aka shubha fil nas, applies, then we will consider it at all costs, irrespective of what the person felt or didn't feel. So shubhatun fil fi'l is overridden or is not even considered, is cast aside when we have shubha fil mahal, aka shubha fil nas. But where there is no shubha being created by the scripture, then we will always turn to or fall upon shubha fil fi'l, in which case we will see what the individual had in mind when he undertook what is otherwise zina, what is otherwise for all intents and purposes zina. Like, I'll give you an example. It'll come, but just so that it's clearer. If a boy and girl got married in a way that their nikah is fasid, if a boy and girl got married in a way that their nikah is fasid, so who can create a scenario like this? So boy and girl got married,
Say
uh,
brother and sister.
their brother and sister. Okay. Yeah, brother by like foster mother, right? Foster as in they're not like haqiqi brother sister, but let's say that they're brother sister through rada'a, through breastfeeding. Or that boy and girl got married and they had one boy and one girl as their witnesses. So two witnesses, but as we will see, you, or if you actually last year you did it, right? You require one male and two females. So there aren't enough witnesses, but somehow they were unaware of this condition, that gender plays a role as well. And so they got married. Now, this marriage is not a valid one in the eyes of the Sharia. And nikah, what we call fasid, and it's not sahih. Now, these two that are living together via an invalid marriage is zina. But do they get had punishment? This is the question. Do we last and stone them? We're saying no. We're saying no. Why? So there's no shubha fi nas here. There's no scripture here suggesting that their marriage is valid. Rather, is mahal. Mahal here is the two people that got like they got married, right? So the sexual relations they had was under the assumption that their marriage is correct. So this is called shubha fil fi'l. Now, if it's the case that both of them came together not for the purpose of marriage, but for enjoyment, or for what is otherwise considered an illegitimate relationship, and he knew what he's doing is actually zina and it's a sin, he'll be lashed for this. He will be lashed or he will be punished for this. There is had here, like that. This is how it works. Are we okay with that, people? So come on then, let's look at the masail now. So this is وَلَا حَدَّ عَلَى مَنْ وَطِئَ جَارِيَةَ وَلَدِهِ وَوَلَدَ وَلَدِهِ. There is no had upon the person, or we can just translate it as the father. There is no had punishment upon the father who has sexual relations with his son's slave girl, or and with his grandchild's slave girl. لماذا؟ شبهة النص. What's the شبهة النص? شبهة في المحل. It's the hadith أنت ومالك لأبيك. أنت ومالك لأبيك. So if Quduri stopped here, if Imam Quduri rahimahullah stopped here, the answer is correct. But here he adds وَإِن قَالَ عَلِمْتُ أَنَّهَا عَلَيَّ حَرَامٌ. Even if the father said that I knew that she was haram for me. Why he brought this here is to demonstrate or to illustrate the principle that I mentioned, that where shubha fil mahal or shubha to nas is present, then we won't even consider shubha fil fi'al. Shubha fil fi'al is not considered, it trumps it. And therefore, even if he says, I knew this was haram, I knew this is zina, we don't consider it because the shubha here is created by the nas. And he says here, وَإِذَا وَطِئَ جَارِيَةَ أَبِيهِ أَوْ أُمِّهِ أَوْ زَوْجَتِهِ. So if you look, Abi, this is father, mother, so it's a son. So if the son had sexual relations with his father or mother's slave girl, or if the husband had sexual relations with his wife's slave girl, أو وطئ العبد جارية مولاه, or that the slave had sexual relations with one of his slave's master's slave girls. So look, in all of these scenarios, there is no shubha fil mahal. There is no nas which is suggesting ownership that is creating doubt for these acts, these cases here. That's why we'll fall upon shubha fil fi'l. And so the Imam says, وقال يعني الواطئ يقول الواطئ الابن أو الواطئ العبد أو الواطئ الزوج علمت أنها علي حرام, that I did what I did knowing that it was impermissible. حدة, it's had punishment here. وإن قال ظننت أنها حلال. However, if he says that actually I thought that this was permissible for me, so the shubha isn't created by nas by his own fi'l. And what's the fi'l here? Is the urf. The urf tends to be that a child uses his father and his mother's possessions, things that they own. He lives in their house, lives with them. He shares, like, for example, if they have an extra house, he has a key to that house. If they have cars, he has access to those cars. Sometimes he may even have access to funds and so on and so on. So it's not that urfan, عرفا in the culturally speaking, it is the case that he has access to it, but shar'an, there's no precedent for this. Hence, there's no shubha being created. So, وَإِنْ قَالَ ظَنَنْتُ أَنَّهَا حَلَالٌ لَمْ يُحَدَّ. If he says, I thought she was halal for me, then there's no had punishment here. وَمَنْ وَطِئَ جَارِيَةَ أَخِيهِ أَوْ عَمِّهِ وَقَالَ ظَنَنْتُ أَنَّهَا حَلَالٌ حُدَّ. If someone had sexual relations with his brother's slave girl or his uncle's slave girl, and then he says, I thought she was halal for me, here there is had. Here we will not even consider shubha fil fa'al. Why do we not say this? Why don't we fall upon shubha fil fa'al here? Allow me to explain. The Sharia considers urf and ada. So whereas in the culture in which Quduri rahimahullah wrote this book, the custom was a child does use his parents, his master slave girl scenarios. They use one another's property and possessions. It is not common, it is not culturally practiced that a brother uses the possession or the property of another brother, or that a uncle or a nephew uses freely the property possessions of an uncle in the way that he does his father's. However, what do you think the however is going to be, people? What am I going to say to you? Do you see where I'm going with this, people? However, if you are part of a culture where your uncle's property is as good as your father's property, and that you have an elder brother who's like a father figure to you, like you see these like it's not even in my culture, is my culture very much like Quduri here, by the way, right? But I'm just saying, like, I've seen in Pakistan, you get those multi-generational houses, yeah, like the 3, 4, 5 story one. Then the uncles and the aunties are all living together, and it's probably the case that they all share business. So they're all one big family where there is free use and so on, so on, like that. So where this is the case, then yeah, we can entertain shubha fil fi'l, shubha fil fi'l. But I'll keep coming back to the point again, which is that fuqaha, they premise these rulings based on akthariyat. So this is considered now like a exceptional case. It's an exceptional case in the culture in which Quduri wrote this book. Because like I keep saying, the fiqhi masail are written based upon akthariyat. The vast majority of the case that is not like this. Hence, he wrote the masail the way he did. Are we okay with this, people? So look, I'm going to read into this masala. وَمَنْ وَطِئَ جَارِيَةَ أَخِيهِ أَوْ عَمِّهِ. If somebody was to have sexual relations with the slave girl of his brother or his uncle. وَقَالَ, and then he says, ظَنَنْتُ أَنَّهَا halal. I thought she was halal, I'm mistaken. There is still had punishment. What Khuduri is trying to say over here is, yes, there's no shubha fil nas, there's no shubha fil mahal, but then we should be falling upon shubha fil fa'al. But here he's saying we won't even consider shubha fil fa'al. Why? Because culturally, it's just unacceptable for a brother to have free access to his other brother's property and possessions as he does with his parents, say. And likewise, a person doesn't have free reign, free access to his uncle or his like great uncle or some other uncle down the road, right? To some stranger in the way that he does for his parents. That's why. Okay. Come on, let's continue then. He says, وَمَنْ زُفَّتْ إِلَيْهِ غَيْرُ امْرَأَتِهِ وَقَالَتِ النِّسَاءُ إِنَّهَا زَوْجَتُكَ فَوَطِئَهَا فَلَا حَدَّ عَلَيْهِ وَعَلَيْهِ الْمَهْرُ. So what's happened here? Well, let's translate it. وَمَنْ زُفَّتْ إِلَيْهِ غَيْرُ امْرَأَتِهِ. You guys familiar with Zaffa Yazifu? We use this you'll find it a lot in your Arabic and Urdu poetry. In Urdu poetry, we have something called Shabe Zifaf. Shabe Zifaf. Or the other way of saying that is Suhagrat, I think is the term they use. Suhagrat. It's the night where the boy and girl, the husband and so the groom and the bride officially meet. Yeah. So what's happened here? If a person was given other than his wife in marriage, وقالت النساء, and the women said, إنها زوجتك, that she's your wife, and thus he had sexual relations with her, there is no had upon this person, and upon him is the mahar. So come on, people, let's get creative and create a scenario. Junaid is already laughing. Okay. Scenario, look at the scenario. A person got married and he had his ruksati walima, right? And he's never seen his wife. Like in certain cultures, no, you're not gonna see your wife. We have to doll her up and make her all nice, and this, put her in that special room and whatever, right? So this person's had his meal, he's about to retire, and all the women are congratulating him, and they say, "Oh, look, your wife is waiting for you. Go in the room." So what does this person do? The groom goes into the chamber, and the girl in the chamber saying, "I'm not your wife." Yeah. The girl in the chamber saying, "I'm not your wife because I'm just a maid. I'm trying to like sort all this out." But somehow he's like, "Listen, you're lying. You're my wife. Everyone just said that you're my wife." You're not running away. And so he consummates the marriage. You see? So is it zina here? So yani, is it zina?
Maybe not for the guy, but possibly for
It,
the woman.
it is zina. No, like if we speak marriage, technically speaking, but there's no
Uh,
had here. Why not? Because this person was mistaken. Haqiqatan, he was mistaken. But why is he mistaken? Because the women told him that, congratulations, your woman's in the, yani your wife is in that room, right? The bride's in the room. So he goes in under the impression that this is my bride, and that she's running away because this in certain cultures you have to act shy, you can't act too happy, and this. So he's like, what is this? I am a man. I have to prove my manliness. Whatever. I need to get creative. You get the point. The point here is there is no had. Why is there no had here? Because shubhatun fil fi'l, and the shubha came about because the women told him who. It's not that he chose to um, what, to not accept her testimony. He chose to not listen to her. He says, how can it be? All the women just told me in outside, give me congratulations, go in your tent, go in your chamber, and he's going in his chamber and he's seen a woman like this. This is how it works. The question then is, why is the mahar? There is mahar because if you remember last year, you would have done this in your kitab nikah. He had relations with her. He had sexual relations with her. Bud'a. لأنه تمتع بها. And if it's the case that she's virgin, then he took her virginity. So she deserves to be given her right, which is mahrul mithli. He will give her the mahrul mithl. Are we okay with this, people? Next scenario. ومن وجد امرأة على فراشه فوطئها فعليه الحد. And whoever found a woman on his bed and he had relations with her, then he will be given the had punishment. طيب لماذا؟ So look, let me give you a scenario here so you understand what this is about. And if you have your Hawashi, it'll help you make sense of this. So let's say Zaid is married to Amatullah. We'll call her Amatullah. Zaid is married to Amatullah. He's been married for 5 years. And then one night, he sleeps with another woman on his bed. And he's claiming that it was dark. And I thought it was my wife. What did he say? I thought it was my wife. Why are the fuqaha not accepting this as shubha fil fi'l? Because they say if she's your wife, then you know your wife intimately. If you've been sleeping with your wife, you will be intimate with your wife and you understand how she feels, her features, and this is a completely different person. So there's no shubha here. There's no shubha here. He would know straight away whether this is his wife or it's not his wife or it's someone else. Come on then. وَمَنْ تَزَوَّجَ امْرَأَةً لَا يَحِلُّ لَهُ نِكَاحُهَا فَوَطِئَهَا لَمْ يَجِبْ عَلَيْهِ الْحَدُّ. And whoever married the woman who was unlawful for him to marry and subsequently had intercourse with her, the had will not apply upon this person. Yani, for example, someone married their foster sister. There will be no had because the person did not know that she was haram for him. So there's shubha here. Okay, there's shubha. But they will say there's ta'zir. There is ta'zir. I've been saying this to you before anyway. That look, when we say la hadda, la hadda, la hadda, doesn't discount the. It's almost like every lesson I'm having to repeat this, right? La hadda doesn't mean that the person gets away scot-free with I don't know, a bunch of flowers and a box of chocolate. No, no. Yeah. Sorry, we have a check question here.
That was in reference to the first scenario.
Yeah, Zainab is saying, would it be different? No,
But
no,
if
no.
she kept saying no, then isn't that I don't
What?
understand, isn't that a problem?
Yeah, but what I'm saying to you here is it is and it isn't a problem. It's a moral problem, but it's not a legal problem.
But wouldn't it be punished legally?
No, no legal punish because there's no physical harm. Like I told you, in certain cultures, this is standard practice. In certain cultures, this is standard practice. Like, look, for example, maybe this is my own cultural biases, but I despise the French for a whole
Okay.
host of reasons. Now, in French culture, it is perfectly acceptable for a man to woo a female in ways that are completely unacceptable here in our culture. So, this thing that she's saying no, but he still thrusts himself upon her. This is like standard practice. So what I'm saying here is that, look, you did Kitab al-Nikah last year, not people. You did Kitab al-Nikah last year.
Yeah.
طيب. So in Kitab al-Nikah, think about what I'm going to say to you now, right? In Kitab al-Nikah, the ijab and qabul that is taking place, the aqd, or what do you want to call it, the marriage contract that is being officiated, solemnized, right, is what? What does it involve?
You giving a permission to have an intercourse. That's what marriage means.
The ijab qabul, yeah, the ijab. Look, it's a contract, it's a transaction. So a transaction, as always, involves what people tamalluk and tamlik, tamalluk and tamlik. So I have here, for example, my iPhone. It's the same iPhone that I've been teaching like 5, 6 years, if not more. Same iPhone, right? So I say, for example, this iPhone here, I am the owner. I'm the ba'i', the malik. I will sell this to Nazim in exchange of £50. He agrees. So we do ijab qabul. Ijab is I'm willing to sell you this Nazim for a exclusive price of £50 only, and he says, Ustaz, I accept. Ijab qabul. So what happens at ijab and qabul? What's the hukum? What are the ramifications? What's the result of this pledge and acceptance? And it's that tamalluk and tamlik takes place. So transfer of ownership, yeah. So as in ownership of this phone has gone to Nazim. Nazim is now the rightful owner of this phone, and he owes me £50. So tamlik form two, tabab tafi'il is transfer ownership. So I am no longer the owner of this, and tamalluk means I gain ownership of £50. Tamalluk tamlik. So you have to ask yourself now, in a nikah where there's ijab qabul, what is the tamalluk tamlik here?
No, I understand that obviously it's with his wife, but she wasn't his
لا
wife,
لا
and she
لا
told him though.
لا 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 اسمعوني جيدا. First, let's be clear. What is the tamalluk tamlik here? Tamalluk tamlik is that the groom owns the bride. This is what it is. We're doing
Is
some
he
revision
owner?
here. We're doing
Is
some
he?
revision here. Does he own like the what is this red pill crew, green pill, all this other masculine,
No, I don't
toxic
know about
masculinity?
that.
No, no, I'm trying to figure. We're trying to establish what does he own, or
Is
what's the transfer here? Because I'm saying like because all of the fuqaha agree that nikah is a contract. Who aqdun. Hence we have ijab qabul. Do we not, people? Yani nikah isn't just a blessing. It is it's a legal contract. That's what it is. هو عقد. And because the aqd it requires ijab qabul, there's no doubt. You know the basics of the format of a contract there. Arkan yani. But the question here is what is it? What is a tamalluk and tamlik in here? Anyone?
isn't it owning access to the woman's vagina as opposed to owning the woman herself?
Jamil. Yeah. So it's not it's not the private parts per se. A bit crude. It's intimacy. Yeah. The man is by the way, it's both ways. Both ways. So the male and female are gaining access to intimacy. This is the word you want to use. Yeah. Now, like I said, this whole red pill, blue pill, every other pill you want to talk about, they've got it all twisted. The reason why we've got it twisted is because there is a fundamental difference between owning a slave girl and and your wife. Your wife isn't your slave. خلي بالك, okay? You're not owning the woman. This is not what the fiqh is saying, right? I told you it's حق تمتع, or if you want to use the term that people have misread, is milkul budati, is the word they use. Milkul buda. So what the person owns, he's not owning the private part, he's owning access to, and it says both ways. Sexual he has access to intimacy. And this ownership, Junaid, you should understand, this ownership is not the ownership of the slave, as I said to you. It's like the ownership of, if you want to use this term, yeah, um, between an employer and an employee. Yani case, for example, if you work at some place, let's say you're working at some company, you have job requirements and a job spec, no? The job will tell you that your job is to come in 9 to 5 and to do X, Y, Z. Your company owns this service from you. This is the language of law now. This is their right. And so, because you've signed this contract where you will provide these services, have you slaved yourself? This is the sort of language we're using, right? If you're gonna get colorful, right? Does your company own you? سؤال يعني, we say no. It's just that you're bound to provide these services. Are we okay with this? Now, this thing that Zaid was talking about, the reason I'm saying this is because I want you to understand what this is now. See, if you've agreed to a nikah contract and now you're disagreeing to the rights that you are bound to, this is fundamentally at odds. You see what I'm saying, Zainab? Do you remember the discussions on shurut?
No,
If
I understand that, but
Well,
obviously the girl isn't the one that agreed. That's what I'm asking. Wouldn't it be classed as a rape crime?
no,
Because she said that she wasn't the woman. She said she wasn't the wife.
she said she wasn't but all the women outside said that she is.
Yeah, but they're not the ones that have to go through whatever she went through.
but
Why
that's
isn't
the
her word
shubha.
the more important word?
No, that's precisely where the where the shubha is, which is why we're considering it shubha and we're not
Maybe
considering
he
anything else.
Ustad, maybe he husband to like she's joking or you know.
That's what I'm saying. That's what I'm saying. Now the thing is, look,
That's his thinking.
Zainab, all the other bits, whether there's ta'zir and if so, how much ta'zir and whether we consider this for our purposes, we're not going to consider because the Imam wants you to consider the had side. The whole purpose of this exercise that we're doing right now is we're just doing some genus differentia to determine whether this person is liable for had or not. Okay, so if you want to create this in a non-traumatic way, by all means do so. Yeah.
I don't know how it's going to be non-traumatic, to be
Not
honest.
not non-traumatic being that the girl is saying to him, the very handsome person, right, who's looking very
Okay.
nice, that look, I'm actually not your wife, and he's like, yeah, you're just joking. Finish, right? Whatever, and he create a scenario where it doesn't have to be so much resistance. Okay, so much fighting. There's no violence involved. None of that involved. Okay, like that.
Okay.
Allahu Akbar. But
Ustad, I see also
remember the
some-
shurut. The shurut discussion is also very important. Yeah, shurut meaning if you have a condition that is fundamentally at odds with the contract itself. So, for example, I am willing to sell this phone to Nazim for £50 on the condition that I don't hand the phone over to him. Well, what does that even mean? Like, do you understand what a sale is? Yeah, I am going to sell this phone to Nazim on the condition I retain ownership of it. Well, then what are you selling? See, like, what is the purpose of sale? So it's like if a female says to a male that I'm prepared to get married to you on the condition that we're never intimate, then why do you agree to the nikah? Because nikah literally means that this person is getting access to intimacy. Or I'm getting married to you on the condition that we don't have any children. So if you
People do
remember,
that nowadays.
people do it. But remember, in the Hanafi madhab, what is our position regarding the shurut fasida? You will have read in Kitab al-Buyu that in the Hanafi madhab, as long as the sale is correct, the shurut fasida or kala adam, they don't exist. So if this is for the boys, if you have an incredibly good-looking female who tells you she's prepared to marry to you on the condition that there's no intimacy, there's no children, you go ahead and get married. The Hanafi madhab, your marriage is done. the condition is null, it's void, it's invalid. Why? Because it's like, did you understand what it means for you to agree to get married to someone? Because nikah literally means this, that you're providing intimacy to the other person. So because it's fundamentally at odds with the condition is fundamentally at odds with what the nikah is, this is shart fasid, and shart fasid are not considered. They're entirely discarded. They're null. They're not enforceable. Tayyib Junaid, what's your question?
So you actually answered my question, because I think one of my questions was about the tamlik thing. So the classical scholars in their books, they didn't consider it as the man having tamlik over the woman. They didn't consider it like that. They considered it specific.
No.
Okay,
I told
that's
you it's like in the way that we discuss employment. Yeah,
yeah,
because
I get it.
unless you feel that because you've signed a contract where your duty where you're bound to come into office and you consider that slavery and you consider that you're owned by your company, you have no will, then maybe that's another discussion. Then we need to reconsider the whole thing. But no, historically, no. The milkiya was milkiya to haqq tamattu, not that you own the female, because otherwise then the question is, what's the difference between owning a female slave and nikah then?
Yeah. But on their exceptions, even to the milkiyah of the haqqut tamattu, like if, for example, one of the partners is like ill or something like that.
That's another discussion. Oh, that's a complete different discussion.
And
Like I
then
said, the way the books are written is with the akthari, with the majority, or with the norm. So the norm being that a female that is getting married is healthy. No doubt about that. Yeah.
No, I mean certain times where they're ill or they're whatever,
Mm,
and they don't want to be intimate with their spouse at that time. It's not like they're going against, if they refuse at that time,
No.
it's not like they're going against the contract.
Look, here's where it gets tricky, Junaid. I'll explain to you why. We're discussing this from a fiqh perspective. And what I mean by this is, I'm not discussing this from a moral perspective. Here we're doing ahkam. Is it valid or is it invalid? Right? Is it sahih? Is it fasid? Is it batil? Is it halal? Is it haram? But clearly, a marriage for me cannot rest on this. Marriage is about love, is about affection, it's about consideration, right? Your fiqh not going to discuss this. In the same way, I say to my students, look, you've been reading fiqh, alhamdulillah, for like 3 years. You've read fiqh of salah, have you not, people? How many times have you read fiqh of salah? How many times have you read fiqh of wudu? But is there ever any discussion on what we call khushu in prayer, presence in prayer, qualitative presence in prayer, of sincerity in prayer? How should your mind be? Focus in prayer, focus in wudu. Why was focus in wudu so important? And what is it as a matter of ritual that you should be feeling? And what are the experiences you should be espousing when praying, when fasting, when making wudu? This is not discussed because this is not the remit of fiqh. You see what I'm saying to you here? So if your marriage rests upon, oh, it's not fard for me to do this, or it's not wajib for me to do this, then I just feel like this is not a marriage that's built on love. This is a marriage built on these boundaries, and I don't think that's a healthy state to be in. You get what I'm saying, Junaid? Yeah. So
Yeah,
our
yeah.
discussion,
That's. I was asking a legal question though. I
yeah,
think
yeah, yeah, yeah.
because my question is about, yeah.
Legally speaking, for example, let's just say the female is ill, and the illness does not have anything to do with access. It's just that she's feeling a bit under the weather. Let's put it like that, right? And let's say the husband thrusts himself upon her without her will. Legally, the qadi is not going to do anything other than say, look, you shouldn't have done this, and maybe say to her that, look, it's important that you provide access to your husband, because then he's gonna go elsewhere, or something else is gonna happen. That's it. So there's encouragement, but I'm saying that there we can talk about this morally, but as a qadi, what else can you do?
Yeah. No, I get that. I was more talking about from the woman's side, as in she can refuse in those situations.
She can refuse, yeah, but there's a hadith that speak about this, that yeah, she can refuse, but what's the word I'm looking for now? She's encouraged. She's encouraged to provide access at all times. That's what I'll say to you. Encouraged. Yeah.
And then the other question I had was about this scenario that we were talking about. Would the woman have any level of like, let's say the woman she didn't resist, and she said, "I'm not your wife," once, but then he kept whatever, and she didn't resist, and wouldn't she be responsible for zina because she knows that's not her husband?
If you got a bodybuilder, right, a guy who's proper worked up, how's she gonna refuse? I'm asking you, yeah, because I think we're thinking about it differently. So if you've got like middle-aged guy who's well built, who's like a bodybuilder, and you've got like a I don't know 17, 18, how's she gonna refuse? Yeah, so this is look, you're always thinking in this other way. What if the person was very, very, very desirable? Okay, let's put it the other way around. And she says to him, "Look, I'm not your wife," and he's like, "Yeah, whatever." What are you gonna do? And ماذا تفعل أصلا?
It's a weird situation, I guess, but yeah.
Come on, Azin, what's your question?
It is also on the similar note. I probably had touched it. In modern days, we have this no is a no. I mean, there are legal examples that sometimes people in the middle of the act says no, and that should be actually respected as a no, and then I'm coming from Norway, and then this is a big thing
You
that
know, Asmin, I am sometimes completely aghast. I myself am lost when I look at some of the modern cases. So you're talking about modern law, yeah, modern culture and law, and where this has gone with feminism, with marital rape, with this. Like, I'll give you an example. One of the first cases that my wife shared with me when she was at law school, yeah, it was the first case they studied. Think about what I'm going to say to you now, yeah, so you understand how far this has gone. So this was a case, Junaid, in Manchester, that a person was in a relationship with a female. For 6 years, they were married, they had relations. And in the sixth year, he realized that the person that he's sleeping with is a man. Yeah. So this person has been sleeping with him for 6 years. And there's details there that they would only be intimate when they're drunk, when the person is drunk. But somehow, in the seventh year, he realizes that this person he's sleeping with is a man, and now he's suing him. I don't even know where to begin with this. Where you begin with something like this? And this is being taken seriously. That, yeah, actually, there's a massive case over here against this. So, this discussion of a no. Or there was another case, Asmil, if actually soon after this case, there was another case where a person, the female had consented. Think about this, right? The female, the boyfriend, girlfriend, or they had a relationship. The female consented, but she had said you can have relations with protection, and the person didn't use protection. So is it rape or not? So she consented to having relations, but with protection, and this person, he used it and then took it off, and then he did something else, and now she's so, like, where do you draw the line? So this Shar'an is the fiqh won't go into this much detail.
Shaka, what you're saying exactly happened in Australia for one
There's
cricketer.
loads of cases. But
Yeah.
I'm saying this is not for us.
Yeah,
this is.
but Sheikh, my question is basically, I mean, there are lots of modern developments as well. So
Yeah.
I would like to know that in Islamic fiqh, when a
Mm.
woman says no, I mean, not a joking no, but it's actually seriously a no.
Yeah.
And then if the man does not respect it, there should be some consequences for that man. So I'm trying to understand that
Yes.
from the
Okay.
fiqh point of view.
So this, because this is not had. Remember, I told you that there are 5 hudud. Let's do this in the way that I want you to approach this topic. There are 5 hudud. Do you guys remember what had was? It was a punishment that the Sharia specifically has set. كل عقوبة مقدرة مستوفاة حقا لله سبحانه وتعالى. There were 5 or 6, however many, if you remember them, right? This one wasn't one of them, was it? So a husband, wife are married, and then the husband said no, and sorry, the wife said no, or the vice versa. It can be both ways, by the way. The husband not feeling in the mood, and the female thrust herself upon him, yeah, like that, or the other way around. This is not going to fall in had territory, is it? Do we all agree that if a husband is thrusting himself upon his wife without her consent, then this is not zina, and therefore he shouldn't be stoned to death, let's say, or lashed. Yeah, do we agree on this? This falls in ta'zir territory then. That's it. As simple as this. Ta'zir, if that. Ta'zir, if that. As in, this now is for the state to decide whether it wants to consider it a crime, and if so, what type of punishment does it want to set?
So that is the Qadi has the power to do that, right?
Yeah, the state,
Yeah.
the Qadi, if we're speaking about this in the modern sense, it's the state
Yeah.
policy. It's not the Qadi will, like, it's ta'zir territory. That's the point I want to make here.
Yeah, that makes it clear. So so basically, I think there should be some consequences, but that is not coming from had, that is coming from ta'zir. Yeah. Okay.
Come from ta'zir. Come ومن أتى امرأة في الموضع المكروه أو عمل عمل قوم لوط فلا حد عليه عند أبي حنيفة رحمه الله ويعزر. وقال أبو يوسف محمد هو كالزنا فيحد. So he says here, if a person يعني أتى امرأة في الموضع المكروه, he had relations with a woman from the rear. موضع مكروه is a dislike area, meaning the rear. أو عمل عمل قوم لوط, or he did the act of the people of Lut, which is same sex relationship, male male. فلا حد عليه عند أبي حنيفة رحمه الله, then there's no had punishment according to Abu Hanifa. يعني إيه معنى had punishment? You know the punishment that we've been setting for the zani of 1,100 lashes, sorry, if he's bikr, non-thayyib, and if he's a thayyib, then we're looking at stoning to death. So that isn't there. فلا حد عليه عند أبي حنيفة رحمه الله. There's no had punishment. Rather, there is discretionary punishment here. وقال Abu Yusuf Muhammad, Abu Yusuf Muhammad are saying it's like zina, and therefore the same had for zina will apply. Are we okay with this? What is Abu Hanifa Rahimullah's argument? Abu Hanifa Rahimullah is saying there's no had here because this act, what act, people? The act of sexual relations from the rear is called liwata. Liwat in Arabic. What do we call it? Liwata. Monas in Arabic, they call it shudud. Shudud. And the female is called, I think, sihaqa. So it's liwat and sihaqa. And liwat and sihaqa is not called zina. Look, I'm calling it this. I'm calling it liwat. Are we okay with that? So because of this, it's not considered zina. Yeah, there are those who've said from our mashayikh that ityanul mar'a fil mawdi al makruh is known as al liwat al saghir. It's a like a what do we call this? It's a type of sodomy, I think is what we use, like that. So there's a difference amongst the companions regarding the punishment of individuals who are guilty of this or who perpetrated this. There are those from the companions who did say what Sahibain have said, that they should be had like this. There are others who've said no, there's ta'zir, and the ta'zir punishments are written. You can find them in your hawashi. It's that the person should be thrown in the fire. Others have said you make him stand against the wall and then you collapse the wall upon him, crush the person. Others have said you take him from a height and then you throw him off a height. And yani wakada wakada. You can look at all of that in your textbooks. Yeah. وَمَنْ وَطِئَ بَهِيمَةً فَلَا حَدَّ عَلَيْهِ. Again, if anyone had relations of the sexual kind with an animal, then there's no had upon this person. Why? For the same reason that we mentioned before, that this is not considered zina. Right? In English, I think, what do they call this? Bestiality, or I would like to call it animal cruelty. So this is animal cruelty. It's not considered adultery or fornication. So here there's no had. Goes without saying, there's ta'zir. As I keep stressing, فَلَا حَدَّ عَلَيْهِ. Here Quduri simply wants to, because we're doing Kitabu Zina, he simply wants to show that, look, is the Haddu Zani being applied, not being applied? But this discussion. ومن زنى في دار الحرب أو في دار البغي ثم خرج إلينا لم يقم عليه الحد. If someone committed zina where people in Darul Harb or in Darul Baghi, i.e. outside of Darul Islam, and then he came to us, as in the Zani, the let's say the Muslim who committed zina outside of Darul Islam, and then comes into Darul Islam asking for the had to be implemented on him, it will not be. Why not, people? لماذا لا? Because as I've said to you, the purpose of hudud is to maintain law and order in Muslim lands. And what takes place, any criminal activity that takes place outside of Muslim lands is outside of the jurisdiction of the Hakim and the Wali. Yeah, so that they'll say this, as I've said to you before, you don't take law into your hands. Meting out these had punishments is the right of the Imam. So places where zina or places where zina has taken place outside of the sovereignty of the jurisdiction of Haqqul Imam is therefore not punishable. Is not punishable. The term is خارج عن ولايته. الزنا وقع في أرض خارج عن ولايته. So it's the duty of the rulers of this Darul Harb and Darul Baghi to mete out punishments in their lands. And if they don't consider it punishable, then it's not punishable. Simple as that. Yeah, so I'm not sure if you guys studied Darul Harb and Darul Baghi. I usually discuss this topic in Kitabul Buyu, where we have that case where Quduri rahimahullah cites the Hanafi position that there is no riba between the Muslim and the non-Muslim in Darul Harb. That's where I tend to have discussion of this DR business of lands. Darul Islam, Darul Harb, Darul al-Baghi is put here. Baghi over here is not, Baghi can also mean adultery. It doesn't mean it's a brothel or a whorehouse. Here, Baghi, they've said, is from Baghawa. So here we're looking at, it's a piece of land that has been taken by rebels. Rebels, yeah? Wallahu ta'ala a'lam. Here, I'll say something else because I don't know what you did in the DR section of Kitab al-Buyu. Some of this has to do with sovereignty, but understand that sovereignty doesn't mean necessarily that you own the place. It has also something to do with recognition. Allow me to explain. Like, the UK as a sovereign state, let's take Norway as a sovereign state, right? Both countries can choose to have an agreement where they acknowledge each other's law. And what that means is, if someone committed a crime in the UK and fled to Norway, and the UK wants to prosecute them, we can ask for them and they will cooperate. Yeah, it's like EU law. I think this is a nice example is EU law. So if we consider EU to be like Germany, but EU law is applicable across the board. So this is what we mean by sovereignty. So it can be the case that, let's say, we have a neighboring non-Muslim territory that recognize Sharia or recognize sovereignty of Islam. Think of like a vassal state under the Ottoman Empire, something along those lines. Then it's doable. Like something like this will work. Yeah. So the land, when we talk about Darul Islam, Darul Harb, and these things, it's not necessarily who's in power, though there's an element of this, but it is primarily legal. I'll say this. Yeah, it's a essay that I tend to share by Mona Zafar Ahmad Ishaq Ansari on this, where he discusses how the DR discussion has been politicized in the modern period by ideologues. But if you look in the books of fiqh, it is a legal discussion before it becomes a very charged political discussion. What there? Come to Junaid. Yes, what's your question?
What was my question? Oh, I was going to ask about yeah, is that also the case with ta'ziyah or what's it called?
Ta'zir.
Ta'zir, sorry. Yeah, ta'zir. Like the imam can't. There's no ta'zir on this person either who's
Nope.
done zina outside of Dar al-Islam.
Nope. Absolutely.
Mhm.
So look, crimes committed outside of Darul Islam, it is not the duty of Darul Islam to punish them. See, it's not punishable. It's the duty of the rulers of the land in which these crimes took place.
Yeah, and obviously because you recognize their law as well, so you recognize that they should have. Okay, thanks.
Come on, the next discussion. So we're done with Babu Zina, the first had. Let's move on to the next had then. Babu Haddi Ashurbi. Is that what you have in your text? Babu Haddi Shurbi. Okay, so this is what then, if you recall, I mentioned to you that there were two separate hads. There was the Haddu Shurbil Khamri, and then there was Haddu Asukri min Ghairi Khamri. Remember this, yeah? That in the Hanafi madhab, you have two separate had punishments. So there's a had punishment for drinking any amount of khamar, and we will talk about khamar, or there's a section that will come, Kitabul Ashriba. We will discuss what khamar is in much more detail. But the accurate translation for khamar per the Hanafi conception of it is wine. What is it called? Wine. Khamar is wine. So do you agree with me that beer is not wine? Beer, people, is not wine. Whiskey is not wine. Sake is not wine. What other beverages that people drink?
Vodka.
Vodka is not wine. Yeah, vodka is not wine, like that. So khamar, as you will see in the Hanafi madhab, is a good translation for it, is wine. There's a few minor details, differences, but this for now I think is good. So in the Hanafi madhab, wine is absolutely haram, and drinking any amount of it is liable to the had punishment. But for other than wine, it's sukur, a sukur min ghayri al-khamri. So if somebody is found, let's say, with beer, then there's no had upon this person. There is ta'zir upon him. There's ta'zir. The only time you would give the had punishment is if this person is found drunk or intoxicated from the non-wine product. Are we okay with this? Come, let's move on to the book then. He says, وَمَنْ شَرِبَ الْخَمْرَ فَأُخِذَ رِيحُهَا فأخذ وريحها موجودة منه فشهد الشهود بذلك عليه أو أقر وريحها موجودة فعليه الحد. Quduri rahimahullah is saying, وَمَنْ شَرِبَ الْخَمْرَ, whoever drank khamar, aka wine, فأخذ, and he's captured, wow is haliyah. He's captured in a state that the smell of wine is still on him, is present. فَشَهِدَ الشُّهُودُ بِذَلِكَ عَلَيْهِ, and the witnesses testified while the smell is still on him. أَوْ أَقَرَّ وَرِيحُهَا مَوْجُودَةٌ, or that he confessed while the smell is still there in his mouth or on his clothes or whatever. Actually, not on the clothes, just in his mouth. فَعَلَيْهِ الْحَدُّ, then the had punishment is upon that person. If you look at the next one, وَإِنْ أَقَرَّ بَعْدَ ذِهَابِ رَائِحَتِهَا, or you might have رِيحِهَا لَمْ يُحَدَّ. If he has confessed after the smell has gone from his mouth, then there is no had punishment. If you guys remember when we did the zina, we talked about zina mutaqadam. There was that term that if somebody came to testify against a case of adultery, and the adultery is dated, and we said dated was what? That the person had ample amounts of time to come and testify against this person, but he chose not to, and it's coming 15 years later. We said there's no had. Why is there no had? because now that this testimony is seen as suspect. The same here as well. Yeah. So here also we apply this dated business, recent versus dated or expired. So yani, as he's mentioned here, if the smell has gone, then this is considered dated. But where the smell is present, this is considered what? That is recent. Is recent. Unless, of course, we can somehow demonstrate that there was udhr. Like I said to you, in the zina case, we saw that somebody wasn't able to come and testify sooner than later because he was snowed in, because of avalanche, because something happened, because of corona, because the imam went on hajj and he's just come back now. Where you can demonstrate this, then the had punishment will be applied. وَمَنْ سَكِرَ مِنَ النَّبِيذِ حُدَّ. So what is nabith, people? Nabith, again, we will read in much more detail. It is a date-infused drink, intoxicating drink. So like, whereas wine is pressed grapes, nabith, as we will see, is dates infused intoxicant. Yeah. So if somebody got drunk from nabith, then there is had punishment. يعني ما الفرق بينهما? What's the difference? Well, if you look at the previous one, he says من شرب الخمر لا من سكر من الخمر. So that's the difference I was stressing to you guys, that drinking any amount of khamar liable to the punishment, but from nabith, no, sakir, السكر منه يلزم الحد يوجب الحد وإلا فلا التعزير فقط. Yeah, like that. So he says, and whoever got drunk or intoxicated from nabith, then the had punishment will apply to them. We said the had is 80 lashes, as we will see. Yeah. And we'll discuss more nabis and tila and khamar and all the other different types of intoxicants, and which one is liable to the drinking had and which ones are not. Junaid, what's your question?
Wait, Ustad, so for the first one, it's the guy, he just smells of khamar. I'm not
No
sure if I
smells
missed it.
in his mouth.
Okay, so his mouth smells of khamar.
Yeah. Because so let's just say, right, Junaid, let's just say this guy's mouth has no smell of wine, but his clothes do, or his
Yeah.
shoes do. Here, there's doubt that actually he was just walking and someone threw some wine on him.
Yeah.
You
But
see
I
what
mean, there can still be doubt even in his mouth. You can say, I don't know, he just used it as a mouthwash.
Yeah, it's coming. This discussion is gonna come. Discussion gonna come. Don't worry. Yeah. So, what's the chances of you having? Yeah. Okay. Let's wait for that to come, Junaid. Yes, Muqsid.
Sorry, Ustad. So I assume there's no hard punishment on someone who eats food to which wine has been added, because the smell of wine has probably been dissipated or has disappeared. Does that make sense?
Yeah. No, see, it's still haram. Remember this, yeah? What do we call this? They call it cooking wine. Cooking wine has a greater percentage of alcohol than your average wine. And it is almost impossible for it to evaporate. This is one discussion. Second discussion is, remember that wine is najis. So it's like you're adding impurity to a small amount, small quantity. If you remember the whole discussion in water in the Hanafi madhab, where you have impurity in water, we will look at whether it is a large amount or a small amount, the 10 by 10 discussion. And the rule is, if najasa is introduced in ma' qalil, then the entirety of the water becomes impure. So if you've got a dish in which you've added a drop or a couple of drops of wine, then that entire dish, because it's less than 10 by 10 cubits worth of whatever soup or whatever pasta you're making, the entirety of the pasta is now impure, it's najasa. You see the problem that we're falling into. If you want to talk about non-wine discussion, then that's a different one. But yeah, so in that sense, whoever asked that question, there's no had, because remember, what was the had? Let's spell it out again. The had was shurbul khamri. What was it, people? Shurbul khamri. This person he's not drinking wine, he's consuming it, he's eating it. أكل يعني الأكل غير الشرب أليس كذلك? Like go back to the zina and liwat discussion that we just did a minute ago with Abu Hanifa rahimahullah, right? That this person, he's not drinking wine, he's eating it, right? And that he's consuming it. He's slurping his noodles, right? So he's slurping it. He's not drinking it, like whatever phrase you want to use. It's not drinking. You get that? So for that reason, had may not apply to him. Yeah. But there's ta'zir. Mm. When would it be had? Maybe if he got drunk from it. But I don't know. Do people get drunk from food that has wine in it? Yeah, there's your answer then. No.
I don't think so.
Yeah, I don't think so as well. I don't think so. ولا حد على من وجد منه رائحة الخمر أو تقيأها. And there is no had upon a person who is found with the smell of alcohol, Junaid, even in his mouth. So if you find alcohol smell on someone, see, either you're going to have witnesses saying, yeah, we saw him drinking wine. Yeah. Or he himself will come and confess. But just because he has smell of wine in his mouth, or that he vomits it out, there's no had punishment. Why not? There's shubha. There's shubha that this person didn't really drink khamar, he drank something like khamar. The smell, right? Like that. So I know, as we've been saying that we had punishments are dropped due to doubt. So here there's doubt.
Because there's no witnesses.
Because it could be something else.
But in the first scenario, obviously there was witnesses.
Yeah, in the first scenario, there was witnesses that we saw this person with a bottle and he was drinking it. In fact, he is the bottle. And that bottle, Junaid, is not your mouthwash bottle. Okay, this is like some, I don't know, you have to get creative. Some nice type of wine.
Yeah.
Yeah.
Yeah, it's fine.
And if he vomits out wine, then there's no had why. Because again, there's doubt that there's no khamar. But let's assume that this person, what he vomits out is pure wine. There's no doubt about it. We'll say that maybe he was forced to drink it, or there were some other circumstances. So we'll give him the benefit of the doubt. There's no had. So as I keep saying, the Sharia wants to conceal sins. It's not interested, it's not bloodthirsty. It's not like, we want to lash as many people as we can. Yeah. ولا يحد السكران حتى يعلم أنه سكر من النبيذ وشربه طوعا. He's saying a drunk person will not be punished until it is known for certain that he has become drunk from nabidh and that he has drunk it with consent. For example, you found someone drunk, right? You're the Qadi Junaid of Baghdad, found someone drunk. Do you just had the guy and straight up just had him, give him the 100? If he's so drunk, he won't even feel anything. He'll wake up saying, "Oh, I got a headache." No, we're not doing that. Why? Because it's possible that he got intoxicated from something else. So what did he get intoxicated from? Maybe he had pakoras that were laced with marijuana. That's where he got drunk from. Or he had some mare milk or something. We'll read about it in Kitab al-Ashriba. Discussion will come. So the thing is, what's the point? The point is we want to know what he got drunk from. This is one. Number two, we want to know whether he drank this by force or whether he drank this out of consent. Because if he was drunk, if he was forced, then there's no had. But if he drank it out of choice voluntarily, then there is had. Are we okay with that? So look, in summary, when you find a drunk person, you want to figure out two things. What substance did he get drunk from? Number one. Number two, did he drink that out of choice? طوعا. طوعا, yeah, طوعا, as opposed to karha. ولا يحد حتى يزول عنه السكر. And he will not be punished, i.e. the had punishment will not be meted out until he becomes sober. Why? Because, like I said to you, you want to lash this person, punish them, and they need to feel the pain. So if he's drunk, he won't feel the lashes, will he? Like that. وحد الخمر والسكر, يعني حد شرب الخمر والسكر من غير الخمر. This is what he's trying to get at here. So the had punishment for drinking any amount of khamar and getting drunk from non-khamar substances or beverages, fil hurri, in a free person, ثمانون سوطا, is 80. Is 80. So for the female and the slave, we're going to half it, as we will see. يفرق على بدنه كما ذكرنا في الزنا. These 80 lashes will be spread up amongst his body, as he mentions in Kitab Zina. Don't strike on the head and don't strike on the same place 80 times, because the purpose is to give this person pain and not to destroy his body part, not to make the body part redundant. وإن كان عبدا فحده 40 صوتا. If he is a slave, then it's half of 80, so we're looking at 40. ومن أقر بشرب الخمر أو السكر people, ثم رجع لم يحد. Whoever confessed, إقرار is confessed. Whoever confessed drinking alcohol or drinking wine, whoever confessed in drinking wine was sakar. We will look at this beverage in Kitab al-Ashriba. It's a non-khamri drink, sakar. So this is not sukur, but sakar. So whoever drank wine or another non-wine drink, ثم رجع, and then he retracted, the had will not apply. Do you remember in Kitab Zina, someone came and confessed that he's done zina, and then as he was about to get stoned, he's like, no, I didn't commit zina, and then we let him off. We don't apply the had upon this person, because we took his confession as truthful the first time round. He's still truthful according to us now. Same thing here. So somebody came and confessed that he drank alcohol, that he drank wine, right? And then you start lashing him, that no, I didn't drink it. رجع عن إقراره, if you want to spell it out, right? من أقر بشرب الخمر أو السكر ثم رجع عن إقراره لم يحد. Then you won't go ahead with his had, and we will accept his retraction. ويثبت الشرب بشهادة شاهدين وبإقراره مرة واحدة. And شرب الخمر will be proven via 2 male witnesses or via his confession once. This the Imam brought here to show you that again is contrasting it with zina. In zina we required 4 male upright witnesses. Here it's half of that, so 2. And in zina we said we required 4 testimonies or 4 confessions in 4 different sittings. Here 1 is enough. 1 is enough. ولا تقبل فيه شهادة النساء مع الرجال. As I've been saying, as I mentioned at the very beginning of this Kitab al-Hudud, female testimonies are not accepted in any of the hudud. So women don't testify to zina, women don't testify to haddu shurb al-khamri wa sukri min ghayr al-khamri. Why is this? Because we mentioned that there's a shubha fi nas here. The female testimonies are not accepted because there is shubha fi nas, or shubha fil mahal. And the shubha fil mahal is what? the ayah which mentions that you should have two female witnesses and not one, lest one forget and the other remind her. Remember that one? فإن لم يكونا رجلين فرجل وامرأتان ممن ترضون من الشهداء أن تضل إحداهما فتذكر إحداهما الأخرى. So أن تضل, there is shubha that she can err, she may forget. So that the other, so like that. So there's shubha created by the nas. So we will not accept female testimonies in meeting our had punishments. So ولا يقبل فيه شهادة النساء مع الرجال, and therefore female testimonies will not be accepted alongside male ones. Done. Any questions regarding this then? حد الخمر.
I have my question from last week, but not regarding it.
Go on then, let's have it, because I don't think
It
we've
was
got much
actually
time.
it was actually from the week before, but it was about you know, when we were talking about the muhsan, and we were talking about the different conditions of the muhsan, and you said that they have to be a mu'min, not a kitabiyya. And then I think I asked, why is there a difference made between kitabiyya and mu'min? You said because the mu'min has kamal al-ni'mah. I didn't understand what you meant by that.
So I don't have all of the conditions in front of me, but I remember some of them. If you have the conditions of the muhsan, what was the last condition? That both of them, yani the husband and the wife, share the same conditions, that they're Muslim, that they're aqil, that they're baligh, there's nikah sahih, there's dukhul. Yeah, like that. So
Yeah.
if you think of a person married to a kitabiyah, then one condition is being lost, isn't it? That she's not Muslim. So let's say Zaid is married to Jenny, who's a Christian. Okay. Jenny here is aqil. She's baligh. She's not Muslim. But then she's also a nikah sahih dukhul biha. Right? So he's got married to her in a proper, legitimate way, and that he's consummated the marriage as well. Even then, this Zaid will not have the had al-muhsan. So he won't be stoned to death, but he'll be lashed. Why? Because he's not muhsan. You got that? He's not muhsan. What? Why? Because the condition is not being met. The last condition was that both the husband and the wife, the male, female, are of this description that we mentioned. Of description that we mentioned, and so that's that's the reason. If you want to speak about this in just technical terms, this is why. The reason why the person is not going to be stoned is because he's not muhsan. Yeah, and rajam was reserved for what? Zani muhsan. الرجم كان لزاني محصن. And because this person is zani غير محصن, so he'll be lashed 100 times. But the question is why? So it's because, as the fuqaha mentioned, that a Muslim woman is given a value and importance that a non-Muslim woman is not given. The assumption being that a person, a Muslim, has married a proper Muslim woman, she would satisfy him in every which way. She would bring him hasab and nasab. She'll bring him honor, she'll bring him status, she'll bring him everything. He had everything, and despite that, he chose to go and do this haram. So it's completely unacceptable. So this one by Kamilun Ni'mah. So our fuqaha mentioned that a Muslim wife that meets all of the categories, that all the conditions of muhsan, yeah, that she was aqil, that she was baligh, there was proper nikah, there was dukhul, all of this means that this person had access to complete ni'mah fi ni'mah, is blessing upon blessing. And this is absolute betrayal of this. Complete betrayal of the highest order means he should be given the most severest punishment. Like that. This is what they say. Yeah, so getting married to a slave girl, getting married to a kitabiya is not kamilun ni'mah, it's naqisun ni'mah. This is why he's not muhsan. This is why he's not muhsan. Yeah, chaste is the term they're using it for muhsan.
Yeah. Okay, that's fair.
We finished Abdul Azim. Time's up. Okay, come on, we stop here then. Subhanallah bihamdihi, subhanakallah bihamdik, nashhadu an la ilaha illa ant, nastaghfiruka wa natubu ilayk. Assalamu alaikum wa rahmatullahi wa barakatuh.